Ready? Start. The following two issues of law arise for consideration in these two petitions: whether the arbitral tribunal is mandatorily required to take a decision on the plea referred to in subsection 3 of the Act before it proceeds further in the matter, or it can decide such a plea at a later stage while making the arbitral award. If the arbitral tribunal decides to go ahead with the arbitral proceedings without taking a decision on such a plea, or if it rejects the said plea, whether such an order of the tribunal can be interfered with in exercise of writ jurisdiction under Article 226 or 227 of the Constitution. The petitioner before this court, in response to the statement of claim and also by filing a separate application under Section 16 of the Act, challenged the very initiation of arbitration proceedings on the ground that there was no arbitration agreement between it and respondent number 2. It was also pleaded in the said application that disputes, if any, could not be classified as maritime dispute, attracting applicability of clause 60 of the agreement between the parties, and the agreement dated 4/12/2007 does not fulfill the ingredients of an arbitration agreement as prescribed in section 7 of the Act. The aforesaid application, however, was not decided by the arbitral tribunal, which was of the view that on the first date of hearing the claims should be decided and adjudicated. This was followed by 3 more applications before the arbitral tribunal seeking a decision of the issue of jurisdiction, competence, and validity of the arbitral tribunal. The arbitral tribunal, however, decided to proceed with the matter without giving decision on the applications filed by the petitioners. Being aggrieved from the order of the tribunal dated 5/7/2013 deciding to proceed with the matter, the petitioner is before this court seeking quashing of the aforesaid order, besides a direction terminating the mandate of the arbitral tribunal. The petitioner before this court, on receipt of notice from the arbitrator, raised a preliminary objection with respect to maintainability of the arbitration proceedings inter alia on the ground that there was no arbitration agreement between the parties. The arbitration-wide impugned order date 15/6/2013 rejected the preliminary objection of the petitioner. Being aggrieved, the petitioner is before this court seeking quashing of the aforesaid order date 15/6/2013 in contending that the arbitral tribunal is required to decide the issue of jurisdiction as a preliminary issue before taking any further pleas in the arbitration proceedings. The learned senior counsel for the petitioner in WPC number 6328/2013 laid emphasis on the words where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceedings, and make an award used in subsection 5 or section 16 and submitted that ignoring the aforesaid mandate of law is likely to visit the parties with consequence of having to suffer in terms of the wastage of time and incurring huge cost. If at the end of arbitral proceedings the tribunal was to hold that it had no jurisdiction in the matter. He further submitted that right to appeal conferred by Section 37(2) of the Act in the event of the tribunal acceding to the plea of want of jurisdiction or exceeding the scope of its authority, as the case may be. It was felt by the High Court that it is surprising that the deceased was burned to 90% and she might have moved around writhing in pain, and during this process the articles kept inside the room might have caught fire, but these circumstances were not found. Further, it has come in the prosecution evidence that the deceased was making complaints about the torture meted out to her by her in-laws at her matrimonial house in lieu of dowry demands, and it has further held that the appellant's accused persons also could not explain the reason for the deceased having committed suicide at her matrimonial house. Thus, the High Court came to the conclusion that the death of the deceased cannot be said to be in normal circumstances. Therefore, the High Court held that it can be safely presumed that this is a case of dowry death against the accused persons in whose house the deceased had died due to burn injuries. The petitioners have prayed for quashing the order dated 27/8/2013 passed by Subdivisional Judicial Magistrate Sasaram Rohtas in complainant case number 589 of 1998 corresponding to trial number 48/2013 for the offences punishable under sections 498A, 494 or 34 of the Indian Penal Code. Source is 3P Legal RHC and exercise number is 48. Total words are 753 and speed is 100.